The term free on board, or FOB, is commonly used in contracts for the sale of goods. What role does this common term play in determining when ownership of the goods passes from the seller to the buyer? We explore that question in the 1955 case, Swift Canadian Company versus Banet. Swift Canadian Company of Toronto agreed to sell lamb pelts to Albert Banet and others who were doing business as Keystone Wool Pullers in Philadelphia. The contract provided that the pelts would be sold for a set price per piece, FOB Toronto, and would be shipped by rail to Keystone in Philadelphia. The contract further provided that neither party would be liable for any governmental orders or acts. Swift delivered part of the order by placing pelts on a railcar in Toronto and shipping them to Keystone in Philadelphia. The first delivery went off without a hitch. Then, the United States government enacted a regulation that prohibited the importation of the remaining pelts. When Swift notified Keystone that it was ready to load and ship the rest of the pelts, Keystone cited the new regulation and refused to accept the shipment. Faced with Keystone's refusal, Swift didn't load the pelts onto the railcar and ended up selling them to another buyer. Swift sued Keystone for breach of contract and sought to recover the difference between the contract price and the price at which the pelts were actually sold. The trial court denied Swift's motion for summary judgment and granted Keystone's. Swift appealed to the Third Circuit.